abortion is that there are too many. Actually, the U.S. is headed toward reducing abortions. According to Newsweek, since at least 2006, Obama has been talking about abortion reduction, a holistic approach to pregnancy and parenthood that includes not just legal abortion, but also sex education, access to birth control, good prenatal care and postnatal support, and adoption services. Also, according to USA Today, legislation in Congress supported by pro-life and choice leaders, such as the Pregnant Women's Act, aims to reduce the abortion rate in the U.S. by 95% in 10 years by enacting many of the social and economic supports highlighted in the study done by the Catholics in Alliance for the Common Good. The same studies done by the Catholics in Alliance for the Common Good from 1982 to 2000 found that benefits for pregnant women and mothers, such as employment, economic assistance to low-income families, quality child care for working mothers, and removal of state caps of children eligible for economic assistance in low-income families have reduced abortions. And if morality is also a concern that our opponents have, morality might not even be a concern in adopting this amendment. U.S. abortion foes say Planned Parenthood is flushed with cash and shouldn't get taxpayers' money while the economy is floundering. The new lobby tactic by conservative Christian groups focuses more on the economic concerns than moral concerns, and this is reported by the Wall Street Journal. According to Country Watch, the Republican National Committee will no longer offer its staff an insurance plan that covers abortion. The RNC Chairman Steele said that the plan covered elective abortion, a procedure that the party's platform calls a fundamental assault on innocent human life. Yet their current policy had been in effect since 1991. And in insolvency, a constitutional amendment to prohibit abortion will suffer the same fate that previous similar amendments and laws have faced. According to the New Catholic Encyclopedia, during the 1970s and 1980s, the Supreme Court most often interpreted the privacy right announced in Roe quite expansively and invalidated state laws regulating or restricting abortion. From 1976 to 1986, for example, the court held that a husband's interests in his unborn child are not greater than a wife's right to seek an abortion, and that parents have only a limited right to direct their minor daughter's abortion decisions, and in a separate case, that safety regulations may not be imposed upon abortion clinics if compliance would create significant financial obstacles to women seeking abortions. Again, according to the New Catholic Encyclopedia, after Roe versus Wade, in response to Roe, a movement arose in the 1970s to add a human life amendment to the federal Constitution. Two leading versions of this amendment were proposed. The first would declare the unborn human life a constitutional person entitled to the 14th Amendment's protection of life. A second would allow all states, if they wished, to pass laws protecting the lives of the unborn as they had before Roe. While there arose significant momentum for such an amendment over the course of the 1970s and early 1980s, no such amendment has yet passed.